Mic check 1, mic check 2. I don't hear myself in my IFB. Hello? Oh, say that again? Okay.
Oh my gosh, all the commercials killing me.
Which number do we call?
Oh, Ken,
The old one?
what is my phone number? Yes, this one, that one. Yeah, home. Thank you. Scared me for a minute. That, yeah, the other one was the old word. Good. I gotcha. Yes, I can hear you.
today. If you could please have some representative get one to me before you leave this morning, that would be amazing. And I think we got 2 more, Grand Rapids Press and Fox 17. So I did get those if either of you.
Good morning, I'm Kirk Montgomery. We are interrupting regular programming with breaking news as a Kent County judge is about to announce his decision on whether the case against the former Grand Rapids police officer Christopher Schurr will head to trial. This comes after 2 days of testimony last week from a total of 8 witnesses, including 2 officers and neighbors. Let's listen in live now as County Judge Nicholas Ayub announces his findings.
All right. Good morning, everyone. As the court indicated on Friday, it did have time to review the proofs and the law and has prepared a written memorandum of opinion. I intend to read from that written memorandum. Portions will be verbatim. I won't include reference to annotations or citations. They will be in the written document. The court does have a handful of copies of the written opinion that we can make available when we are through. And the opinion will be available on the court's website in just a matter of about 5 or 10 minutes when the court is through giving its opinion. So anyone who would like to see the written opinion that will be available to the public in just a matter of a few minutes. Anything from counsel before the court goes ahead and reads from the opinion?
Nothing from you, Your Honor. Tell you that.
Okay. All right. Defendant is charged with second-degree murder, MCL 750.317. A preliminary examination was conducted on October 27th and 28th, 2022. Following the presentation of proofs by both parties, the people moved the court to bind defendant over on the single charge of second-degree murder. The relevant underlying factual background is not in dispute. On April 4, 2022, defendant Christopher Schurr was a police officer with the Grand Rapids Police Department on duty and on assignment patrolling the city's southeast side. Just after 8 a.m., defendant initiated the traffic stop of a Nissan Altima after observing that the license plate on the vehicle was issued to another car. Before defendant fully exited the police cruiser, the driver of the Nissan, who was later identified as Patrick Lyoya, stepped out of the Nissan. Defendant shouted at him several times to get back in the vehicle, and Lyoya did not comply. Defendant asked him if he spoke English, to which Lyoya responded yes. Defendant asked Lyoya if he had a driver's license. Lyoya indicated that he did and told the passenger in the Nissan to hand him the license. Lyoya did not wait for the passenger to hand him the license. Instead, Lyoya abruptly closed the door of the vehicle and walked towards the front of the car in what appeared to be an attempt to get away from the officer. Defendant responded by telling Lyoya to stop and reached out to restrain and handcuff him. Defendant was unable to immediately restrain Lyoya, and after a struggle, Lyoya was able to break free from defendant and ran around the back of the Nissan into the adjacent residential front yard. Defendant pursued Lyoya, yelling at him to stop, and is heard radioing out, quote, "We've got one running," close quote. Defendant reached Lyoya on the side yard of the neighboring house. Defendant was able to grab him from behind. While this prevented him from running, defendant struggled to fully restrain and take control of Lyoya. Defendant continued to yell commands at Lyoya to, quote, "stop," and to put his hands behind his back. While Lyoya said, "okay," he continued to struggle and was not complying with the officer's commands. Defendant is seen striking Lyoya's abdomen with a knee multiple times with no apparent effect on Lyoya. Lyoya appears completely impervious to and unaffected by the officer's attempts to subdue and restrain him. By this time, the homeowner in the adjacent house, Wayne Butler, came outside to observe what was occurring. Butler testified that he didn't want to see anyone get hurt, and so he felt compelled to plead with Lyoya to follow the officer's orders, saying, quote, "Come on, bro. I came down for your own safety, man. Come on, comply with him," close quote. Butler testified that he was also encouraging Lyoya's passenger to tell Lyoya to comply and get on the ground. Defendant then pulled his taser from his utility belt. Lyoya grabbed the front of the taser with his left hand. Defendant immediately commanded Lyoya to, quote, "let go of the taser," close quote. Lyoya did not comply. The taser discharged one of its 2 cartridges, which lodged in the ground without striking anyone. The 2 continued to struggle over the taser. Defendant and Lyoya struggled to the ground, with Lyoya underneath defendant attempting to take exclusive control of the taser. During the struggle, the taser's 2nd cartridge was discharged. Lyoya attempted to get up, raising his legs and arms in an apparent attempt to throw defendant off of his back. At one point, defendant's arms and legs are seen fully suspended in the air as Lyoya pushed up from beneath him. Ultimately, Lyoya gained exclusive control of the handle of the taser and was able to transfer it to his other hand. All the while this went on, defendant continued to shout the commands, quote, "drop the taser," close quote, and, quote, "let go of the taser." Being unable to retain any control of the taser, and with Lyoya continuing to attempt to force himself up, defendant used his right hand to draw his service firearm and aimed it at Lyoya's head. Defendant then straightened his left arm while keeping the gun in his right hand, pointed it at Lyoya's head. Defendant yelled one final time, quote, "drop the taser," close quote. Seconds later, defendant fired his weapon, shooting Patrick Lyoya in the head. The Kent County Medical Examiner, Dr. Stephen Cole, testified as to his opinion that Patrick Lyoya's death was homicide caused by a gunshot wound to the back of the head. This court also heard the testimony of Brian Childs, a representative of the manufacturer of the taser. He explained that the taser involved here contained 2 cartridges capable of projecting electrical probes up to about 20 feet. If the probes on the cartridges made contact with a person, they will deliver electrical energy that will cause the person temporary neuromuscular incapacitation, or, quote, NMI. A person struck with the probes is rendered completely unable to move for around 5 seconds. He explained that once both cartridges have been deployed, the base or handle of the taser is still capable of delivering a drive stun. A drive stun delivers localized pain to the part of the body touching the front of the taser. However, a drive stun does not result in NMI. Once ejected, the probes can be retrieved and reactivated. However, unless the probe has made sufficient contact with a person or unless the conductive material on the wire has been exposed as a result of damage to the wire, the taser is only capable of delivering the more benign drive stun that will not result in NMI. The court also heard from Captain Chad McCursey of the Grand Rapids Police Department. Captain McCursey trains police officers and is certified as a master taser instructor. He opined that defendant followed policy and procedure in this case, and that use of deadly force was justified under the totality of the circumstances. He explained the criteria that is considered when evaluating questions concerning the use of force. He also cautioned about the importance of evaluating questions from the circumstances as they appear to the officer and not with the benefit of hindsight. He also testified that a number of alternative techniques and responses were available to defendant, but that the policy recognizes the discretion the police officer has to make those decisions in the heat of the moment. Captain McCursey offered an example of other tools and techniques that were available to defendant at the time of the incident, including pepper spray or the use of the flashlight, baton, or radio to strike the suspect. He explained that even in using the firearm, an officer is taught that they may aim at different parts of the body depending on the level of force that is necessary. He also indicated that it is impossible to know whether Lyoya simply intended to break the grasp of the officer or to actually affirmatively attack him. Ultimately, Captain McCursey is of the opinion that the defendant followed his training and policy based on what the totality of the circumstances required. After hearing counsel's arguments, the court took this matter under advisement to review the testimony and law in greater detail. Moving on to the analysis of the opinion. It is of primary importance to understand the limited scope of this court's authority and task as it presides over a preliminary examination. In Michigan, the preliminary examination serves the public policy of ceasing judicial proceedings where there is a lack of evidence that a crime was committed or that the defendant committed it. Recognizing the risk associated with standing trial for a felony, the preliminary examination, like the grand jury process, serves as a check on the power of the executive branch of government to proceed with a criminal prosecution. The grand jury has been described historically has been described as the protective bulwark standing solidly between the ordinary citizen and an overzealous prosecutor. And that is from the U.S. Supreme Court case of the United States versus Dioncio, 410 U.S. 1, 1973. However, the scope of judicial review of a criminal prosecution at the preliminary examination is very limited. The judicial officer at the preliminary examination is tasked with making the legal determination of whether there exists the minimal amount of evidence the law requires to justify continuing the criminal prosecution. While the court makes that legal determination independent of the prosecutor's decision to bring criminal charges, the court is prohibited from second-guessing the prosecutor's charging decision. Rather, if the magistrate determines that probable cause exists to support the charge under the law, he is obligated to bind the defendant over for trial. A failure by the court to bind the defendant over in that instance would amount to nothing less than the court's unconstitutional usurpation of power otherwise belonging exclusively to the executive branch of government, and more specifically to the county prosecutor. Stated more plainly, while the court operates as a check on the prosecutor's power to bring criminal charges, it is a very limited check. The court does not have the authority to veto the prosecutor's charging decision in the same way that the governor or president can veto a bill passed by the legislature proposing a law or policy that the governor or president does not like, does not think will work, or does not think is fair. The court can only determine whether the charge is founded upon probable cause. If it is legally sound, the court cannot stand in the way of the criminal prosecution, regardless of what the court might think about the prosecutor's decision to bring charges, or even the likelihood of conviction by a jury. In other words, the limited question for this court is whether the criminal prosecution can continue as a matter of law without any regard for whether the prosecution should proceed based on anything other than the law. At a preliminary examination, a court is tasked with determining whether a felony was committed and whether there is probable cause to believe the defendant committed it. Probable cause exists where the evidence is sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the accused's guilt. The evidentiary standard is far less rigorous than that required for a conviction following a trial. And I'll read here from the case of People v. Yost, which is a Michigan Supreme Court case from 2003. At the examination, evidence from which at least an inference may be drawn establishing the elements of the crime charged must be presented. The probable cause standard of proof is, of course, less rigorous than the guilt beyond a reasonable doubt standard of proof. Probable cause requires a quantum of evidence sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the accused's guilt. Yet, to find probable cause, a magistrate need not be without doubts regarding guilt. The reason is that the gap between probable cause and guilt beyond a reasonable doubt is broad, and finding guilt beyond a reasonable doubt is the province of the jury. In order to establish that a crime has been committed, the prosecution need not prove each element beyond a reasonable doubt, but must present some evidence of each element. And probable cause may be established purely by circumstantial evidence and reasonable inferences arising from the evidence. During the preliminary examination, the magistrate is not only the right, but also the duty to pass judgment not only on the weight and competency of the evidence, but also on the credibility of the witnesses. However, the court is not to apply the same measure as a jury because of the differences in the standard for bind-over and for ultimate guilt. Again, reading from the Supreme Court's opinion in People v. Yost, the Supreme Court explained, the gap between probable cause and guilt beyond a reasonable doubt is broad, and therefore, unlike a jury, a magistrate may legitimately find probable cause while personally entertaining some reservations regarding guilt. Accordingly, in considering credibility of witnesses, a magistrate may only decline to bind over a defendant if a witness's lack of credibility, when considered together with the other evidence presented during the examination, would preclude a person of ordinary prudence and caution from conscientiously entertaining a reasonable belief of the accused's guilt. Indeed, the magistrate or judge may very well be left with reasonable doubt the defendant committed the crime charged, and yet at the same time find probable cause to bind over a defendant on that charge. Moving on to the elements of the charged offense here. The elements of second-degree murder are, number 1, a death, number 2, caused by an act of the defendant, number 3, with malice, number 4, without justification or excuse. As a necessary element of second-degree murder, malice reflects the principle that criminal culpability must be tied to the actor's state of mind. Malice is defined as the intent to kill, the intent to cause great bodily harm, or the intent to do an act in wanton and willful disregard of the likelihood that the natural tendency of such behavior is to cause death or great bodily harm. Second-degree murder is a general intent crime and does not require a finding of specific intent or harm to kill. The intent to do an act in obvious disregard of life-endangering consequences is a malicious intent. There is no real question here concerning the first 3 elements of the charged crime. There is little doubt that Lyola's death was caused by the gunshot wound to the head inflicted by defendant. The clear depiction of the incident in the video strongly infers that defendant knew he was pointing the gun and firing it at close range to Lyola's head, which, in turn, is sufficient to establish probable cause to conclude that defendant acted with malice. The only real debatable question here is whether defendant's actions were justified under the law. a person is not guilty of a crime even though the person committed the illegal act if a legally recognized justification is factually supportable. At trial, the prosecution has the burden of disproving justification beyond a reasonable doubt once evidence is introduced. For purposes of bind-over, the court must determine whether there is evidence that is sufficient to cause a person of ordinary prudence and caution to consciously entertain a reasonable belief that the homicide of Patrick Lyoya was not justified under the law. Defendant presents 3 theories that he argues establishes clear justification as a matter of law such that no probable cause exists for bind-over. Number 1, that he used force reasonably necessary in defense of himself or others. Number 2, that he used appropriate force in response to force used by Lyoya to avoid arrest. And 3, that he used reasonable force to prevent a felon from fleeing to avoid capture. We'll begin with the theory of justification by self-defense. While modified by statute in certain respects in recent years, Michigan law governing self-defense remains primarily a creature of common law. At common law, a claim of self-defense, which is founded upon necessity, real or apparent, may be raised by a non-aggressor as a legal justification for an otherwise intentional homicide. The ultimate question requires a factual determination of whether the accused, under all circumstances of the assault, as it appeared to him, honestly believed that he was in danger of losing his life or of great bodily harm, and that it was necessary to do what he did in order to save himself from such apparent threatened danger. Thus, the homicide of Patrick Lyoya would be justified under the law of self-defense only if the defendant honestly and reasonably believed his life was in imminent danger or that there was a threat of serious bodily harm and that it was necessary to exercise deadly force to prevent such harm to himself. Our Supreme Court made it clear that, quote, the touchstone of any claim of self-defense as a justification for homicide is necessity. And indeed, the court confirmed that generally questions concerning the existence or lack of reasonableness or necessity in resorting to deadly force in self-defense are for the jury to decide after considering all of the circumstances. Some conclusions concerning the use of deadly force for self-defense can be made as a matter of law. For example, the general rule under the common law was that a person first attempt to retreat and avoid the danger before being justified in using deadly force in self-defense. However, by operation of law, both common law and more recently by statute, the duty to retreat is completely excused under certain circumstances. For purposes of this case, there is no dispute that defendant was legally pursuing Patrick Lyoya and was therefore legally on the front lawn of a private residence at the point of the shooting. Therefore, under Michigan law, MCL 780.972, defendant did not have any obligation to retreat rather than use force. Nonetheless, factual questions remain as to whether defendant reasonably believed that his life was in imminent danger or that he was in imminent danger of suffering great bodily harm and that deadly force was reasonably necessary. These are questions of fact that the jury must decide based on the totality of the circumstances as presented by the evidence at a trial. And indeed, our jury instructions recognize that the ultimate determination of reasonableness and necessity are questions for the jury to decide based on all of the circumstances. Among the standard jury instructions that would likely be read at trial, the jury would be instructed. And I'm going to read from the jury instructions here. The defendant must have been afraid of death or serious physical injury. When you decide if the defendant was afraid of one or more of these, you should consider all of the circumstances. And then in parenthetical, the condition of the people involved, including the relative strength, whether the other person was armed with a dangerous weapon or had other means of injuring the defendant, the nature of the other person's attack or threat, whether the defendant knew about any previous violent acts or threats made by the other person. And at the time, the defendant must have honestly and reasonably believed that what he did was immediately necessary. Under the law, a person may only use as much force as he thinks is necessary at the time to protect himself. And when you decide whether the amount of force used seemed to be necessary, you may consider whether the defendant knew about any other ways of protecting himself. But you may also consider how the excitement of the moment affected the choice the defendant made. And that's the end of the quote from the Michigan Standard Criminal Jury Instructions. While defendant has made strong arguments that the circumstances establish reasonableness and necessity, this court cannot make that determination here at the preliminary examination as a matter of law. The evidentiary record from the preliminary examination contains enough to allow a person of average intelligence to conclude that defendant's fear was not reasonable, or that the defendant's shooting of Lyoya in the back of the head was not reasonably necessary. Captain McCursey testified that it's not clear to him whether Patrick Lyoya was merely trying to get away or was prepared to offensively attack defendant. Captain McCursey also recounted a number of examples of alternative techniques that may have been available to defendant. Based on the testimony, the threat or danger that the taser presented may not be the same, depending on whether it was only capable of delivering a drive stun at the time that the shot was fired without resulting in NMI. And it is not clear whether defendant knew or should have known that both the taser's cartridges had been discharged. These are all circumstances that might affect how a fact finder would assess the necessity question. While the captain is of the opinion that the techniques and actions defendant applied were appropriate, a juror would be free to conclude that under the circumstances, the use of deadly force in the manner it was used by defendant was not reasonably necessary. Importantly, the court does not raise these examples to suggest that defendant's actions exceeded what was reasonably necessary. To be clear, this court expresses no opinion on that matter or the ultimate guilt or innocence of defendant. As explained previously, that is not the question before this court. The law recognizes that law enforcement officers are required to make split-second decisions of life and death in dangerous and strenuous circumstances. The reasonableness of those actions can hardly be fully and fairly judged by one person in a black robe with 20/20 vision of hindsight and from the comfortable and safe vantage point of the high perch of the armored-plated judge's bench. It is precisely, though, for this reason that questions of reasonableness and all questions of fact are determined by a jury after a full and fair trial. Accordingly, for purposes of the probable cause standard, there is sufficient evidence from which a jury could conclude that defendant did not reasonably believe that his life was immediately at risk, or could otherwise conclude that the use of the particular force used was not reasonably necessary. Moving on then to the second theory of justification, force in response to force used by a person being arrested. Defendant's remaining two theories of justification concern the use of force in making an arrest of a suspected criminal. Defendant points out that the defense in that context can be divided into two categories: the use of deadly force when a person making the arrest is met with force from the person arrested, and secondly, the use of deadly force when necessary to prevent the person who is to be arrested from fleeing. The first category, however, is not a distinct theory of justification from that of self-defense. Rather, it is sometimes highlighted as its own theory because it always excuses any obligation to retreat. Therefore, for the purposes of this case, the theory is completely duplicative and indistinct from the justification of self-defense. As the court already indicated, under Michigan statutory law, the defendant did not have a duty to retreat before resorting to deadly force. And for the same reasons discussed, for purposes of the probable cause standard, there is some evidence from which a jury could conclude that defendant's belief was not reasonable or that his response was not reasonably necessary. The most complex of the three defenses raised is the so-called fleeing felon rule, which under certain circumstances justifies the use of deadly force to prevent a felon from escaping arrest. The complexity is not in its application. To the contrary, if applicable in its purest form, the rule is as draconian and unforgiving as it sounds. Blackstone, the famous English commentator on the common law, observes, quote, "Any private person and any peace officer may arrest a fleeing felon, and if they kill him, provided he cannot otherwise be taken, it is justifiable," close quote. And in 1985, the United States Supreme Court observed that Michigan was only one of 4 states that still followed the rule. And according to one commentator, today Michigan is the only state that continues to follow the rule in its purest common law form. Instead, defendants suggest that there's a lack of complete clarity as to some aspects of the rule under Michigan law. While the rule has been subject to calls for legislative reform for the past 30 years, that has not occurred. Importantly, this court's task and the extent of any court's authority is the determination of what the law actually is, not what anyone else, well, not what it or anyone else thinks the law ought to be. As a matter of public policy, reasonable minds can disagree about the extent to which police officers should be free to make judgment calls without the potential for incurring criminal culpability. This court must simply find what the law is now with any consideration of how it might be changed in one way or another. The 1990 Michigan Supreme Court case of People v. Couch controls the question of what the law is in Michigan today. And while there may be nuances that remain, the primary components are readily discernible and are, at least for purposes of making the probable cause determination required here, more than clear. Under Couch, the common law fleeing felon defense, as it existed in 1846 at the time that the crimes of murder and manslaughter were codified in the state's first penal code, continues to be the governing law of this state. Under that common law fleeing felon rule, the use of deadly force is justified if, number 1, evidence shows that a felony actually occurred. Number 2, the fleeing suspect against whom force was used was the person who committed the felony. And 3, the use of deadly force was necessary to ensure the apprehension of the felon. For purposes of the questions before us today, it is clear that even under this broad and rather forgiving rule of justification, the question of necessity remains tightly wound around its core, requiring an answer to the question of whether the actions of the police officer were reasonably necessary under the circumstances to ensure the apprehension of the felon. And no different than the necessity component at the core of self-defense, necessity to ensure the apprehension of the felon is a question of fact for the jury to decide. In applying the probable cause standard, there is at least some evidence from which a person of average intelligence could conclude that defendant's shooting of Lyoya in the back of the head was not reasonably necessary to prevent his escape. As the prosecutor suggests, at the instant that the shot was fired, Lyoya is not in a position of actively escaping or fleeing. A reasonable juror could find a lack of necessity for deadly force strictly for the purpose of preventing escape. Therefore, for the foregoing reasons, the court concludes that as a matter of law, Probable cause has been presented to support the charge in the criminal complaint. Accordingly, it is the court's legal obligation to bind defendant over to the 17th Circuit Court to stand trial on that charge. And that is the end of the court's opinion. Mr. Bergola, does your client wish to waive circuit court arraignment at this time?
We do, Your Honor.
Okay, then if you would execute the written waiver. Is there anything else we need to address before the court adjourns?
Nothing for you, Your Honor. Nothing to defense, Your Honor.
Okay, then the court will sign the order binding defendant over to the circuit court for trial. Once the court signs that order, this court will no longer have jurisdiction of this matter. Bond is continued at this time. I want to thank, again, counsel, staff, and everyone in the media, and everyone that was here, and everyone that has a strong interest in this matter, for your respect, for your courtesy, for your patience, while this procedure and process played itself out. I do want to wish everybody here, everyone who has been touched by the facts and circumstances that were presented over the past couple of days, the peace, hopefully that you find peace in the coming days, regardless of what those coming days may hold. Thank you, everyone. Take care. We are adjourned.
And as we just heard, Kent County Circuit Judge Nicholas Ayub saying there is probable cause that finds to bind the defendant over to the circuit court to stand trial. So former Grand Rapids police officer Christopher Schurr will stand trial for second-degree murder. We want to get right out to our Meredith Tuhar, who is down near the courthouse, to get reaction from what is happening outside there after the judge has now made this decision. Meredith?
Kirk, you summed it up well. You just heard Judge Nicholas Ayub, former Grand Rapids police officer Christopher Schurr will head to trial on a charge of second-degree murder. The district court judge just announced that there is enough evidence for Schurr to be put on trial for second-degree murder and the shooting death of Patrick Lyoya in April. The court has just recessed. People are coming out quietly now. After 2 days of testimony and evidence in last week's preliminary hearing, Judge Ayub said he was taking the weekend to review everything. The prosecution argued Schurr had intent to kill Lyoya, while the defense argued that Schurr did everything he was trained to do. We heard from several witnesses during the preliminary trial last week, including 5 for the prosecution and 3 for the defense. Lyoya's passenger said that Lyoya had gotten out of the vehicle to check on a noise it was making, alluding that perhaps Lyoya didn't know he was getting pulled over. Another witness described telling Lyoya's passenger to try and calm him down during the altercation. Again, after reviewing the testimony and evidence over the weekend, after 2 days of the preliminary hearing, Thursday and Friday, Judge Nicholas Ayub has decided to bind over Christopher Schurr to trial, and jury selection will begin. Now, our hope is to hear from Patrick Lyoya's family shortly. We also hear from all the attorneys involved in the case as well, from the defense to Kent County Prosecutor Chris Becker as well. Kirk?
All right, Meredith, thank you so much. Again, Schurr is facing second-degree murder charges, which carries a potential sentence of life in prison if convicted. Again, this shooting happened on Monday, April 4th, right around 8 a.m. near the intersection of Griggs Street and Nelson Avenue Southeast in Grand Rapids. But again, as we heard earlier, Judge Nicholas Ayub saying there is probable cause and that former Grand Rapids police officer Christopher Schurr will stand trial for second-degree murder. Now, the final witness to testify during the hearing was a Grand Rapids police captain with more than 20 years of experience who is a defense tactics instructor and master taser instructor. According to his testimony, Patrick Lyoya was resisting and obstructing arrest, which is a felony offense. The police captain also outlined factors that may have impacted Schurr's decision making at the time of the struggle, including things like exhaustion. Lyoya had a weight advantage and he attempted to disarm the officer by taking his taser. In his testimony on Friday, the captain says he believed that Schurr did everything he was trained to do. Okay, Lou Lingham is joining us now. He is a use of force expert. Thank you so much for joining us, sir. We appreciate your time this morning. What is your reaction to today's news?
Well, understanding what the judge had to decide on this particular case, whether or not to bind over Christopher Schurr or not, to circuit court for trial. I didn't expect anything any differently because of the standards that are set out and what the judge needs to decide, which is there probable cause to believe a crime was committed, and is there probable cause to believe that the defendant, Officer Christopher Schurr, committed that crime? If so, it goes forward to circuit court for the jury to make a final determination.
All right, thank you. So we want to get right to Chris Becker, who is making a statement right now to the media. Let's see if we can dip in and listen to what he has to say.
Any other standard we've ever had in a
case for the court.
And you think you have the evidence for that?
I obviously, if I wouldn't be proceeding this case, if I didn't think there was something we could do with that.
Mr. Becker, what difference do you think it made going after the second-degree murder charge rather than a manslaughter charge? How do you think that affected your case here?
I guess I don't understand the question. I think it's a second-degree murder. I think the elements of second-degree murder are there. That's why I charged it. I mean, I don't think it had an impact here. I think that's just what the elements, as the judge put in his opinion, that's what the elements are, and I think there's a sufficient basis to go to trial.
Cool.
Sorry if it was already asked, but do you know the timeline for when arraignment for the trial?
There's no arraignment. He waived circuit court arraignment here today. So the jury trial, that's a good question. Like I said, I think there's going to be an appeal, so that could set things out depending on what judge gets it. There's going to be briefing in front. It goes to circuit court judge first, then they have a right to take it to the Court of Appeals, and the Court of Appeals decides to take it. That delays it. So at this point in time, I don't know where or when it's going to be. Normally, we'd have a circuit court judge in about probably 3 or 4 weeks. There'll be a settlement conference within 60 days. But that's going to be a little bit different because I think I'm sure they're going to appeal.
So you're talking next year. You're talking next year.
No question, next year at the earliest, sure.
How can you say that Patrick was lying on the ground when he was on his, that this is at the point when the gun went off, when he's on his knees?
Well,
you said in your closing arguments he was lying on the ground.
He's on the ground, yeah.
Lying on the ground?
That's on the ground. He's definitely on the ground. So that'll be
Lying, though?
that'll be for the
That's
jury.
lying.
That'll be for the jury to decide.
What, hands and knees you call lying on the ground?
That'll be for the jury to decide. That's what we're here for, and that's what the judge found it. So
Doesn't seem lying, but.
no, that's one interpretation. That's what we have juries for, and that's what we have citizens of
So
Kent
you would
County.
define lying on the ground on your hands and knees?
I'm just going with what the facts show. So that's what the judge has found. So, yep.
We've been listening to Kent County Prosecutor Chris Becker and his reaction to the fact that Judge Nicholas Ayub says there is probable cause and that former Grand Rapids police officer Christopher Schurr will go to trial for second-degree murder in the death of Patrick Lyoya. We want to go back to Lou Lingham, former MSP trooper and detective, 25 years, currently a professor of law with WMU's Cooley Law School. Thank you so much for your patience. This is all happening rather quickly, and I appreciate you staying with us. Moving forward now, how this case has gathered, national attention, international attention. How difficult is it going to find jurors who have not heard anything about this case?
Well, it is going to be difficult, and I don't think the standard is going to be whether or not there's jurors out there that have not heard about this case. It's whether or not they are willing, the jurors, whether or not they are willing to listen to all the evidence that will be presented in the trial and withhold any judgment whatsoever until all the evidence is in. And if they can agree that whatever they may think now, if they can agree to wait to hear all the evidence before they make a decision on the guilt or innocence of Officer Christopher Schurr, then they will be allowed more than likely to sit on this jury.
And I'm reminded, the last big trial we had was the kidnapping trial of Gretchen Whitmer, and that the jurors in that case were never sequestered. Do you think they might be under these circumstances?
Probably not. Maybe their identities might not be known for obvious reasons, safety reasons. But as far as the jurors being sequestered and put up in some undisclosed location pending the outcome, probably not. It really depends upon what's going on at the moment that the trial actually gets started and underway next year. But more than likely, it's 50-50, but more than likely their identities may be withheld, but I'm not quite certain whether or not they're going to be staying in some hotel for a couple weeks until the trial's over.
All right, Lou Lingham, thank you so much for your time this morning. We certainly appreciate it. If you're just joining us, we want to give you a quick recap. Kent County Judge Nicholas Ayub says there is probable cause and that former Grand Rapids police officer Christopher Schurr will go to trial for second-degree murder in the death of Patrick Lyoya. He is facing this charge, which carries a potential sentence of up to life in prison, all stemming from that fateful morning on Monday, April 4th. Stay with 13 on your side as we continue to follow this case through. As you heard and understand, the trial will not happen until next year. So look for our updates on our website, on air, and our 13 Plus app. Thank you so much for joining us for the special report. We will see you again starting at noon and extensive coverage again at 5 and 6. Have a great day.
This has been a breaking news report from 13 on your side.